In this video, we will conclude our discussion about the dangers of a university student disciplinary hearing by discussing 3 inherent flaws in this process. That discussion is coming right up. Welcome to Gustitislaw. If you are new here, I'm Steve Gustitis and this is my channel. I post weekly videos about how to manage encounters with the police, defend criminal charges, and how to effectively navigate the criminal justice system. I welcome comments and I welcome questions in my videos, and you can add those in the comment section below. This video is part 3 in our series on the dangers of university student disciplinary hearings. Links to parts 1 and 2 can be found down in the description section below. The first inherent flaw that we'll talk about today is the inherent bias in favor of the university in this hearing process. The officials who are making decisions about a student's educational career typically work for and get paid by the university. How can they not be biased in favor of their employer, the organization that puts food on their table every week? Even if these officials get training on how to be fair or impartial, do you really believe that they will ever make a decision in favor of the student that places their university in a bad light? I think not. So the inherent bias in favor of the university is the first inherent flaw. The second inherent flaw in this university discipline process is the student's inability to hire an advocate to speak for them during the hearing process. In a typical university setting, the student represents themselves. The student does the talking, the student asks the questions, and the student makes the arguments. Frankly, 20-somethings are ill-equipped to be an advocate for themselves in these types of high-pressure and often high-stakes environments. Even if the student hires a lawyer to advise them and shepherd them through the process, it still is not the same as having the lawyer do the talking for them. So the second inherent flaw is the inability of the student to hire their own advocate. Number 3, the last critical flaw in this disciplinary process is the student's inability to compel witnesses to appear and testify for them in their defense. In criminal court, an accused person has the right to subpoena witnesses and force them, compel them to come to court and testify. Not so in the university disciplinary hearing process. If a witness does not want to come to the hearing and testify on the student's behalf, they don't have to come. And consequently, if that witness was a key person in the defense of this case, their testimony will simply never be heard. I'm curious, do you know anyone who has ever been involved in a university student disciplinary hearing? And have you identified other flaws that may exist in the process? If you have, consider putting those in the comment section below, and we will begin a discussion based on your life experience that may be helpful to other people as well. I appreciate you being here and visiting with us and being a part of the Gustitislaw community. If you enjoy the content on Gustitislaw, consider subscribing.